Hi folks, welcome back to another one of our videos. Today we're going to talk about beneficiary designations as part of the estate planning process. Specifically today we're going to talk about beneficiary designations for retirement accounts. Before we get into the video, my name is Chuck Benzine. I'm an estate planning and probate law attorney here in near Detroit, Michigan. We do probate law, we do estate planning, we work hard to protect your family and protect your friends by making sure that your wishes are followed. So let's get into the meat of the video, the topic today. Beneficiary designations. The important thing to remember about beneficiaries for accounts is they remove those assets from your probatable estate. So they're very good for keeping those assets out of probate, and we typically see them, we're all familiar with life insurance, where you would name somebody to receive the benefit of that life insurance. Those are the beneficiaries. They are also available for things like your 401k accounts, your 403bs, your IRAs, those tax advantaged accounts where you've been putting money over the course of your lifetime or maybe just the last few years, and have not been paying taxes on those funds, and you've been able to defer those taxes over your lifetime and use those funds as part of your retirement. Now, there have been some significant changes in how those beneficiary designations are named and how the assets that are part of those tax deferred accounts, those retirement accounts, are treated after someone passes. There was something called the Secure Act that was passed 4 or 5 years ago at the time of this video that made some significant changes to how those taxes are treated. Prior to the Secure Act, if we had a retirement account, we could name a beneficiary. For example, a parent could name a child. That child would then be able to make a decision on how they wanted to handle those assets that are now becoming part of their estate, whether they wanted to remove them, take them out of the account. If they did that, they had to pay taxes because, of course, there were no income taxes paid on any of those funds. If they removed them from the account, they paid taxes immediately on whatever was removed. Or they could have elected, under the prior law, to do something called a stretch. What they would do is they would invest those funds in their estate. They would take those funds and defer the taxes until they started to remove them when they retired. So if you think about it, somebody has a parent die when they were 40 years old, for example. They could take parents' IRAs or parents' retirement accounts, put them into an IRA in their name, stretch those accounts over their lifetime, so that could be another 30 or 40 years, depending on their age when they receive the funds, before they would then have to withdraw those funds as part of their retirement. They would take mandatory distributions at a certain age when those kick in. Now, the benefit of that is you're deferring the taxes on that income during your lifetime. That could continue to grow tax-free for 10, 20, 30 years, depending on the circumstances. Now, the Secure Act that was passed a number of years ago substantially changed how we took care of those funds. The Secure Act, the primary change is that whenever those funds come into the beneficiary's accounts, so they're transferred to the beneficiary's name as a new IRA, for example, the Secure Act now says that the beneficiary has to make an election, has to decide how they're going to take those funds. But in any case, they have to receive those funds within 10 years, or they have to take them out of the retirement account within 10 years. So what happens is, let's assume that a son or daughter would receive mom or dad's retirement account when they're 40 years old. If they receive those retirement accounts at that point, then they have to start withdrawing them or finish withdrawing them, more importantly, by the time they're 50 years old. Now, obviously, when somebody is 40 years old, they may be earning, they may be at the peak of their earning curve, or between 40 and 50, they may be getting to their peak. that's going to have a substantial impact upon how much is paid in income taxes for those funds, because those funds coming out of the tax advantaged accounts, out of the IRA or out of the retirement account, becomes taxable to the person receiving those funds at their tax rate. So if they're already in a 1/3 or maybe even 1/2 or whatever their tax rate is at the time, they will pay that tax rate on those funds. And obviously, if they're close to that tax rate, that could push them into a higher tax bracket, because they have to remove a significant portion of those retirement funds, either yearly or over the course of that 10-year period. So that's going to certainly impose a higher tax cost, if you will, on those funds that were inherited from their parents. So the bottom line is, what we need to do as part of the estate planning process is think about how we're going to take those funds, or how those funds are going to be distributed to the next generation, to the children or grandchildren, or whoever that might be. How are we dividing up those funds? Are they being split in a number of different accounts? Are they going to make a significant difference to the parties that are receiving them? And are they going to substantially be substantially reduced because of the tax burden that has to be paid to cover those funds when they're received? So we always recommend, or as part of the estate planning process, I always recommend that maybe a consultation with a CPA or certainly a tax advisor is a good idea, because we want to take a look at, when are we taking those funds out of a tax advantaged account, a tax deferred account, and when are we receiving them? Is it more advantageous for a parent to receive those funds and pay taxes at their tax bracket, or would it be better for the son or daughter or recipient beneficiary to receive those taxes, or receive those tax advantaged funds later and pay taxes at their bracket? So those are all things that you can sort of work out with a CPA. Do some tax projections on both your tax returns and maybe your children's taxable estates, to sort of figure out which way is the better way to go with that. Which way do we want to do with that, and how do we want to structure the transfer of those funds? And then from there, we work it into the estate plan. Do we want to do a beneficiary designation to the children? Do we want to put it in a trust, make it payable to other people, or maybe make charitable gifts or something like that? Those are all things that need to be considered as part of that estate planning process. Again, I'm not telling you that it has to be one way or the other. It's just something that has to be considered. We have to look at, we have to analyze the tax situation of all the parties involved, figure out what is the best way to do that. And that's something that shouldn't be taken lightly, should certainly be examined. We should look at it from a legal perspective, from a planning perspective, from a tax perspective, involving both financial advisors, attorneys, CPAs, tax planners, everybody involved getting together and putting their heads together and coming up with the best way to take advantage of the law as it exists today, to make sure that those we pay the least amount of taxes going forward. So I hope you found this information helpful. As always, like the video, subscribe to see more estate planning or legal content in the future. If you have a specific question, or if you have some burning desire to know something about estate planning or real estate law or probate, put it down in a comment, or send me an email, send me a text, whatever is easier for you, and I will try to get back to you and try to make a video trying to answer some of those questions, or maybe we can get back to you with a simple answer by email, or whatever the case may be. We hope you find the information helpful in these videos, and we of course thank you for watching, and hope to see you again in the future. Thanks. Bye-bye.